Welcome to HIPAA, Emergency Service Provider Operations, an e-learning by McNeil & Company. This course is an overview of the Health Insurance Portability and Accountability Act, often referred to as HIPAA. In this course, we will discuss privacy and security training for providers. The objectives of this course are to define HIPAA, discuss HIPAA compliance and operational issues, and to describe and discuss what is considered personal health information. The learner will be provided information on patient rights, breach notification, and HIPAA regulations with radio transmission, social media, and patient billing. This course will review the recent changes from the updates to HIPAA with the HITECH Act and the Omnibus Rule. For the successful completion of this course, it is strongly recommended that you review your organization-specific policies and procedures for compliance with HIPAA training. Health Insurance Portability and Accountability Act is a federal law that regulates privacy and security of protected health information, which we will refer to as PHI. HIPAA is a fundamental responsibility of providers and staff, which includes legal and ethical obligations. Privacy advocates argued that the law should also have protections for health information and give patients certain rights regarding that information. Congress agreed, and through HIPAA directed the Department of Health and Human Services, HHS, to issue a set of national standards to safeguard health information. Those standards were issued in two sets of regulations. First, the HIPAA Privacy Rule, and second, the HIPAA Security Rule. Since those regulations went into effect, Congress, through the HITECH Act, and HHS, through regulations, amended them, ramped up the HIPAA Enforcement Rule, and added the Breach Notification Rule to HIPAA. We will discuss those changes in more detail later. To better understand HIPAA, the Privacy Rules regulations address the use and disclosure of protected health information by organizations called covered entities. It also established standards so that individuals can understand and gain some control over how their health information is used. A major goal of the Privacy Rule was to assure that individuals' health information is properly protected while not impeding patient care and other business-related activities for providers. The Privacy Rule tries to strike this balance by restricting the use and disclosure of PHI in certain circumstances while permitting the fairly liberal use of health information related to treatment, payment, and healthcare operations. Covered entities are required to comply with the Privacy Rule since April 14, 2003. The Security Rule requires covered entities to implement certain technical and non-technical safeguards to protect what HIPAA refers to as Electronic Protected Health Information, EPHI. Today, ambulance providers are using clinical applications such as EPCRs, electronic health records, and other digital systems to store, transmit, and organize health information. While this can make your operations more efficient, there are many potential risks to EPHI. The Security Rule aims to address those risks while allowing covered entities to adopt new technologies to improve the quality and efficiency of patient care. Covered entities are required to comply with the Security Rule since April 20, 2005. Among other things, a covered entity under HIPAA includes a healthcare provider who transmits any health information in electronic form in connection with a transaction covered by HIPAA. Healthcare providers include all providers of medical or health services, including institutional providers such as hospitals and non-institutional providers such as physicians, ambulance services, and home health and medical providers. But being a healthcare provider alone does not make you a HIPAA-covered entity. You also must engage in electronic covered transactions. Covered transactions include electronic transmissions of healthcare claims or equivalent encounter information, healthcare payment and remittance advice, benefits, claim status, or the enrollment or disenrollment in a health plan. Every provider or service, regardless of size, that electronically transmits health information in connection with these transactions is a covered entity. But remember, simply using electronic technology, such as email, does not necessarily mean you are covered by HIPAA. The transmission must be in connection with a HIPAA-covered transaction, like submitting claims or other transactions, such as checking eligibility for a health plan, referral certification and authorization, attachments of health claims, or healthcare electronic funds transfers. Even if you rarely engage in a HIPAA-covered transaction, you are a covered entity that must safeguard all PHI. Business associates, BAs, are individuals or entities who create, receive, maintain, or store private health information on behalf of a covered entity. The Omnibus Rule requires business associates to comply directly with HIPAA regulations themselves. For example, answering services, medical transcription, IT groups, billing companies, and shredding services are considered business associates. HIPAA covers a healthcare provider whether it transmits these transactions itself or uses a billing service or other third party to do so on its behalf. So if your ambulance service uses an independent third-party billing company to submit your claims, your ambulance service is still a covered entity. Remember, the billing agency submits claims in your ambulance service's name using your provider number. PHI can be in the form of written, verbal, or digital that may include the name of the person, address, identifying numbers, or birth date. HIPAA applies to protected health information in any form that your organization creates or receives that relates to an individual's medical care or payment for that care, if there's a reasonable basis to believe it might identify that individual. The most common sources of PHI for ambulance services may include PCRs and ePCRs, dispatch information, records from other facilities, photos, videos, and verbal discussions about patients. Nearly every record, communication, or other medium containing identifiable health information created or received by your organization is going to be PHI. If it is PHI, you are obligated to protect, use, and disclose that information only in accordance with HIPAA. PHI is completely confidential and property of the organization and applies to patients that are alive or deceased. You cannot use or disclose PHI for any purpose unless permitted under HIPAA. There are 3 instances in which EMS providers can use or disclose PHI without patient authorization. Under HIPAA, ambulance services may use and disclose a patient's PHI for their own treatment, payment, and healthcare operations purposes without patient authorization. The three basic uses are commonly referred to as the TPO uses. You are permitted to disclose PHI under HIPAA for the purpose of treatment. Treatment means the use for any purpose related to providing EMS or health care to a patient. For example, you provide information to an ALS provider on scene with you who is assisting in treatment. You are permitted to disclose PHI under HIPAA for the purpose of payment. For example, you may use PHI to file claims with Medicare or other insurers. You are permitted to disclose PHI under HIPAA for operational purposes. Operations is the internal management purposes, such as quality assurance or quality improvement, licensure, or other similar activities. In addition to using and disclosing PHI for your own TPO purposes, your organization is permitted to use or disclose PHI for the TPO activities of other organizations. In some cases, the other organization must be a covered entity or simply a healthcare provider. Your organization may disclose PHI for treatment activities of a healthcare provider, whether or not the provider is a HIPAA-covered entity. For example, your ambulance organization may provide a skilled nursing facility with a copy of your report so that the facility can provide follow-up care to the patient and have a complete medical record. Your organization may disclose PHI to another covered entity or a healthcare provider for the payment activities of the organization. For example, if you are the ALS provider on a combined response call, you may provide a copy of your trip report to the BLS provider who provided the transport to the hospital and will be billing the trip to Medicare. Your organization may disclose PHI to another covered entity if your organization and the receiving organization have or had a relationship with the individual who is the subject of the PHI. In this case, the PHI shared must pertain to that relationship and the disclosure must be for quality assurance or fraud and abuse detection or compliance. For example, if you are contracted as the transportation provider for a hospital, that hospital is now conducting an internal audit of its Part A ambulance transports and requests that you provide trip reports so that it can determine whether those transports were properly paid by Medicare. You may provide those trip reports to the hospital. Even if HIPAA permits your organization to use or disclose PHI, you must generally make reasonable efforts to use, disclose, and request only the minimum amount of PHI needed to accomplish the intended purpose of the use or disclosure. For example, your organization should never disclose an entire trip report to another party. Unless you are required by law to do so, the patient is requesting the report or the entire trip report is legitimately needed by the entity requesting the information. Another example would be to remove identifying information, such as name and address, from a PCR before using for a quality improvement committee meeting. HIPAA requires that emergency service organizations take steps to comply with the minimum necessary standard. Your organization must implement policies and procedures to reasonably limit uses and disclosures of PHI. The first step is that every emergency service provider needs to identify what PHI each member of its workforce needs to do their jobs, and then take reasonable steps to ensure that employees' access to PHI is limited only to that information. You can add language to your personnel job descriptions and set access controls on your computer systems to limit access to necessary PHI. Limit disclosures of PHI to only PHI needed by the requesting party. When making disclosures of PHI to other parties, providers need to ensure that only the minimum necessary amount of PHI is disclosed. If the disclosure is one that your organization makes on a routine basis, billing for example, you must implement policies and procedures which may be standard protocols that limit the PHI disclosed to that amount reasonably necessary to achieve the purpose of the disclosure. If the disclosure is of a non-routine nature, for example, sharing PHI with a law enforcement officer to help locate a suspect, you must review the request on an individual basis and only disclose the amount of information that is necessary, such as only providing the name and location of the patient if that is all the officer needs. When your organization requests PHI from other parties, you must request only the minimum amount of information necessary to accomplish the purpose of the request. As with the previous rule about making disclosures of PHI, your organization must establish a procedure or protocol to limit any PHI request it makes on a routine basis, such as requesting billing information from a facility. Limit it to the minimum amount of PHI necessary to achieve the purpose of the request. For example, asking only for insurance information. For requests that you make on a non-routine basis, your service must review such requests on a case-by-case basis and only request what you need. The Omnibus Rule grants state attorneys general the ability to bring civil action and seek damages on behalf of their residents for HIPAA violations. Penalties for violations are much worse now with the introduction of the Omnibus Rule in 2013. It has increased penalties up to $50,000 per violation to a maximum of $1.5 million for repeats of the same violations. The Department of Health and Human Services is now required to impose those penalties when violations are found to be willful and criminal provisions are applicable to individuals as well as covered entities and business associates. Exceptions to the minimum necessary standard exist when there are requests for disclosures to another provider for treatment purposes. When a hospital requests your trip report for information to treat the patient, it is considered an exception to the minimum necessary standard. Another exception to the minimum necessary standard may occur with disclosures made to a patient or their authorized representative, such as when a patient requests a copy of all their medical records. Uses or disclosures pursuant to written authorization of the patient are also an exception to a minimum necessary standard. For example, a patient may fill out an authorization form to allow you to use their PHI in promotional materials on your website. Uses or disclosures to the Department of Health and Human Services in connection with enforcement activities permits an exception to the minimum standard. For example, if the Department of Health and Human Services is investigating a complaint from a patient about your organization regarding a Facebook post, and if the Department of Health and Human Services requests records relating to that patient, this is an exception to the minimum standard. Exceptions to the minimum standard may also occur with uses or disclosures required by law. An example of this may be if your organization receives a subpoena for a trip report. Secondary use, or disclosure that cannot reasonably be prevented and that occurs as a result of another use or disclosure that is permitted by HIPAA, is considered incidental uses and disclosures of PHI. If your organization applies reasonable safeguards and follows the minimum necessary standard where applicable, incidental uses and disclosures of PHI do not constitute HIPAA violations. The Notice of Privacy Practices are provided to tell patients about their rights under HIPAA and should contain information about your organization's privacy policies and procedures. It is recommended by HIPAA regulations to give a copy to all new patients and give a new copy to repeat patients if revisions are made. When dealing with the Notice of Privacy Practices, it's important to ensure your patients have received a copy. If you are not sure if they received a copy, give the patient another copy. Always attempt to obtain a signature from the patient verifying receipt of notice at the time of service if possible. If the patient is under duress, unconscious, incapacitated, or is experiencing another serious emergency, focus on patient care first. If the patient is unable to sign the privacy notice, document the reason. If possible, attempt to get a signature of a legal guardian, power of attorney, family member, or facility representative. Patients have the right to access their own PHI, ask for amendments if they believe their PHI to be inaccurate, and make complaints regarding the organization's use or misuse of their PHI. Patients have the right to access PHI in electronic format if your PHI is electronic. They have the right to ask for their PHI to be emailed to any email address they request, even if it is an unsecure email, such as a Hotmail account. The patient also has the right to request that the organization not use PHI to submit a claim to an insurer for payment, but only if the bill is paid in full first. The patient also has the right to receive accounting or a list of all disclosures that includes information such as to who it was disclosed and what specific information was disclosed. A personal representative is a person who is determined by state law, such as a legal guardian, power of attorney, the parent of a minor, or an executor of a decedent's estate, to speak and make requests on behalf of the patient. The personal representative has the same rights as a patient under HIPAA to access PHI and request amendments as well. You must treat the patient's representative just as you would the patient. Additional HIPAA requirements include establishing organization-specific policies, procedures, and training, and making them available to all staff. All organizations are required to designate a HIPAA compliance officer or privacy officer whose overall responsibility is for the organization's HIPAA compliance. All questions should be directed to this person. Any impermissible use or disclosure of PHI is presumed to be a breach, with a subsequent requirement to provide a breach notification to those who are impacted. A covered entity or business associate must consider the nature and extent of the PHI involved, including the types of identifiers. It must consider the unauthorized person who used the PHI or to whom the disclosure was made, whether the PHI was actually acquired or viewed, and the extent to which the risk has been mitigated. With the new HIPAA breach notification requirement, you must notify the patient of a breach of protected health information. The HIPAA compliance officer has specific requirements to follow up with the patient. It is important to review organization-specific breach notification policies regularly and to refer to the policy when a breach has occurred. An organization must also report breaches to the U.S. Department of Health and Human Services through a web portal if non-encrypted PHI is improperly disclosed or if PHI is breached in any other way. Examples of breaches to report may include a stolen laptop, lost patient care report, or a spreadsheet of accounts sent to the wrong person. A covered entity's breach notification obligations differ based on whether the breach affects 500 or more individuals or fewer than 500 individuals. If the number of individuals affected by a breach is uncertain at the time of submission, the covered entity should provide an estimate and, if it discovers additional information, submit updates. If you have any questions, you may call the Department of Health and Human Services Office of Civil Rights, toll-free at 1-800-368-1019. HIPAA permits any disclosure of PHI when it's necessary for treatment purposes. For example, your organization may need to communicate identifying information about a patient to a receiving facility so that the facility can access any records that the facility has about the patient and prepare for the patient's arrival. Radio communications must often be conducted over channels that can be monitored by the general public with a scanner. Some agencies and facilities encourage information that may disclose PHI to be called in on a mobile device if possible. What if someone overhears a name on the scanner? Despite this fact, because the disclosure of PHI is being made for a legitimate treatment-related reason, the secondary incidental disclosure to a member of the public who is monitoring the transmission is considered to be an incidental disclosure and is not a violation of HIPAA. Reasonable safeguards are often common sense and include good reminders, such as speaking quietly when discussing a patient's condition around other individuals not involved in that person's care. Avoid using patients' names in public places or over the radio if it is not necessary. And verifying that you are speaking with the patient or the patient's authorized representative before divulging any protected health information. How do HIPAA regulations impact law enforcement? A patient may disclose their own protected health information to law enforcement or anyone else they wish. HIPAA regulations do not apply to police, only healthcare providers and business associates. For example, if police officers get into the back of an ambulance and speak directly to the patient, HIPAA is not an issue as it is the patient giving their medical information to the police. There are 6 exceptions for protected health information disclosures to law enforcement. It is okay to notify police of certain injuries, such as gunshot wounds, burns, or animal bites, when required by state law. Please check with your HIPAA compliance officer on what is required by your specific state laws. It is okay to disclose limited protected health information to help police identify or locate a suspect, fugitive, material witness, or a missing person, as this does not violate HIPAA regulations. Another exception for PHI disclosures to law enforcement include disclosure about a person believed to be the victim of a crime. If the victim of a crime gives you a simple verbal agreement, make sure you document that you have verbal permission to share protected health information. If the patient is unconscious, it is okay if it is in the best interest of the patient and the officer agrees it will not be used against the victim. We advise that you also document during this instance as well. The final exceptions for protected health information disclosures to law enforcement may occur when it appears the victim died as a result of criminal activity, when a crime has occurred on your premises, or to report a crime at the scene of an emergency. Exceptions to other types of agencies for disclosure of protected health information is acceptable and does not violate HIPAA regulations when it appears an individual has escaped police custody and you have the right to share PHI with police or prison officials. Another exception for disclosure of PHI exists when state law requires you to report abuse, neglect, or domestic violence. Always check with your HIPAA compliance officer. HIPAA strictly prohibits providers disclosing any patient information to any media source. Do not even confirm the identity of the patient. Always refer requests to your HIPAA compliance officer. HIPAA regulations allow for disclosure to the media only when you have been specifically authorized in writing by the patient. Just remember your professionalism when you are speaking with the media and the law. Written policies must be in place when addressing HIPAA regulations and social networking, texting, and photos. Make sure you know the policies. Do not disclose protected health information via blogs, websites, discussion groups, social networks, or other public places. Even when you believe information is de-identified, do not share it. Do not post any patient or incident-related information in any manner. Posts on social media sites can give enough information about a person that friends and family can recognize the patient. Names do not have to be included to be a HIPAA violation, and to post pictures, videos, or accounts of specific calls that may contain anything identifiable on your company website or any other social media sites is simply unethical as a healthcare professional. It may be helpful and appropriate to capture images of an accident scene to help determine mechanism of injury for the attending physician or staff when transporting a patient to a facility. With current technology, some agencies and facilities utilize technology to communicate in real time with FaceTime capabilities between EMS in the back of the ambulance and the receiving facility. Any image, video, or audio recording that could identify the patient is PHI and should be secured in the same manner as you would any other protected health information documents. With the use of cameras and other technology in the field, only use devices owned and issued by the organization. No personal devices should be utilized, as they can become part of a legal investigation. Store all images and video clips securely, as images are the property of the organization. Ensure that your organization has policies and procedures in place if cameras are utilized in the field and that all employees understand them. What about HIPAA regulations and family members of a patient? It is okay to disclose protected health information to a relative, friend, or other person involved in the patient's care, if it is in the best interest of the patient. You may also disclose the transport destination and general condition, including death, to family members or others directly involved in the patient's care. Use your judgment if it's not in the best interest of the patient, such as in domestic violence situations. As always, it's important to follow your organization's policies and procedures, as well as state and federal laws and regulations. Patient refusals can be a difficult situation to navigate at times, but it is important to still follow HIPAA regulations. In instances of patient refusals, thoroughly document the incident. You are still collecting protected health information, even though no transport will be made. Obtain the patient's signature or one from a legally responsible decision maker and offer the privacy notice and make a good faith effort to get a signature acknowledging receipt of that privacy notice. When you are working on an emergency scene with other first responders and other EMS agencies providing care, it is okay to disclose protected health information for treatment purposes. HIPAA regulations allow EMS providers to share information with other responding agencies when necessary for patient care. When the transfer of patient care to a hospital or other receiving facility occurs, HIPAA regulations allow EMS providers to share protected health information with staff members, patient registration personnel, and others who perform treatment or payment-related tasks. Sharing of PHI can be done in a regular place and at a regular voice level, but take responsible precautions to minimize incidental disclosures. During interfacility transports, it is okay for EMS personnel to look at patient records for treatment purposes, as EMS professionals are healthcare providers who are involved in the treatment of the patient, as you are not just giving a ride to the other facility. HIPAA regulations also apply to anyone who deals with protected health information, such as billing staff, managers, the HIPAA compliance officer, and other administrative personnel. When dealing with HIPAA regulations concerning billing and administrative issues, and a request is received from an attorney, most times you must receive a written authorization from the patient to release medical records. The release request must be signed by the patient or legally responsible decision maker. If a subpoena or other legal document is received, always refer to your HIPAA compliance officer. HIPAA regulations state that you must share information with patients when they request it. You must have a policy and procedure in place on how you will verify identity. In person, that tends to be less challenging, as you can oftentimes verify by asking for a picture identification and information such as a birth date or other identifiable information. While the privacy rule allows covered entities to require that individuals request access in writing and requires verification of the identity of the person requesting access, a covered entity may not impose unreasonable measures on an individual requesting access that serve as barriers to or unreasonably delay the individual from obtaining that access. For example, a provider may not require an individual who wants a copy of their medical record mailed to their home address to physically come to the office to request that access and provide proof of identity in person. A provider may not require an individual to use a web portal for requesting access, as not all individuals will have ready access to the portal. A provider may not require an individual to mail an access request, as this would unreasonably delay the covered entity's receipt of the request and thus the individual's access. While a covered entity may not require individuals to request access in these manners, a covered entity may permit an individual to do so, and covered entities are encouraged to offer individuals multiple options for requesting access. A new restriction on payment disclosure is that a patient can request that their protected health information not be used to submit a claim to an insurance company for payment, but that request only needs to be honored if the patient first pays the bill in full. With the threat of cybersecurity and HIPAA regulations, there are several recommendations when dealing with electronic access to protected health information. First, an organization must take security precautions, especially when electronic devices are left unattended. Every user should have a unique ID and password, and devices should have an automatic log-off feature when left unattended for a brief period of time. If an organization enters, accesses, or stores protected health information electronically, administrative, physical, and technical safeguards must be in place to secure electronic protected health information. For example, policies and procedures must be in place, computer servers should be housed in a secure location, and devices should be configured with password security, auto log-off, and backup capabilities. A few additional best practices to keep in mind with electronic protected health information is to never share passwords or give lock combinations to an unauthorized person. Do not download copies of patient data onto thumb drives or other portable devices unless authorized to do so. Covered entities and business associates must conduct a periodic risk assessment and analysis to address risks and offer mitigation, along with having adequate policies and procedures in place. When it comes to HIPAA compliance, one size does not fit all. Your organization will need to take into account the nature of your organization, the makeup of your workforce, and your business needs. Regardless of the approach that your organization takes, you should consult with legal counsel to ensure that your plans, policies, and procedures comply with the most current HIPAA requirements. HIPAA compliance is crucial for your organization. Once you have completed this basic awareness and overview course, it is important for your organization to review what you currently have in place and what you need moving forward to reduce your risk to this exposure. Please make sure you implement and update HIPAA policies and procedures. Provide training to your members and employees on HIPAA to better understand what is within their roles and functions in regards to HIPAA. Make sure you have safety measures in place to safeguard protected health information and act accordingly on HIPAA violations and/or breaches. Ensure that the organization has a procedure in place for complaints and ensure you comply with HIPAA record-keeping requirements. Thank you. For additional information or assistance, please contact the Risk Management Customer Service Line at 1-800-822-3747, extension 176.